live en YouTube, así que creo que directamente voy a presentar la mesa, el panel de hoy, a todos los que nos están escuchando en directo, quienes están también en la sesión en Zoom. Bueno, mi nombre es Mariana Fossati, me acompaña
I
Patricia.
have Patricia Diaz with us, Carolina.
Y esta mesa
E esta
trata
mesa
sobre el
trata
derecho de
sobre o
autor
direito de autor
y el derecho de autor como un obstáculo para de algún modo encarar la situación de emergencia sanitaria, sobre todo su impacto a nivel educativo. Y de lo que vamos a hablar un poco es de las experiencias que hemos vivido en Uruguay, en Colombia y en México respecto de los cambios legislativos en el derecho de autor de los últimos años que de algún modo nos han traído hasta acá, hasta esta situación en la que estamos.
The situation that we're facing today, which is the one that from the legislative point of view and policies and access to knowledge allows us or
¿no?
allows us to face this
Una respuesta
situation. Having an appropriate response or an inappropriate response or difficult or challenging of the pandemics. So in order to have a brief presentation of each one of you, I am a member of Credit Common of Uruguay and I participated in Wikimedia and I work in the process of communications in APC. Salvador is a lawyer, member of Wikimedia Mexico. Carolina is a lawyer, director of Carisma Foundation in Colombia. Patricia Diaz is a lawyer and she works in Uruguay in Proyectos Avisoc, Acts and Societies Laboratory that I work into. We're beginning a research process in this topic. I'm the only no lawyer in this panel, so I've learned a lot from all these lawyer colleagues on these topics, and maybe the most technical decisions I may not give them
estou muito bem assessorada.
company. So we're going to do these brief presentations and Patricia and I were going to talk about 15 minutes, 10 minutes, Carolina 10 minutes, Salvador, and then we're going to have an exchange of questions and answers. So you can leave your comments on the chat and if we are prepared, then we're going to start. I'm going to turn into a panelist now, briefly, to give you an introduction to Uruguay's situation with regards to the regulations of copyrights and the changes experienced in the last years, and the fights and discussions that we've had in order to have a better balanced law in agreement with the times. And this is the law that we have today and that we see as an obstacle to be able to face the situation when we have a health situation. I want to tell you the most recent things that have happened for us. This has not been good news, which is the extension of the copyright term in Uruguay for copyright and other connected rights. The post-mortem in the case of copyright, and from 50 to 70 years for the application of the work for attached rights. This change that happened in December 2020 was very fast. It was discussed throughout last year, but didn't seem to become concrete, but it did happen in the last week of sessions of the parliament in Uruguay before we changed the government period. And we voted on the same day. So this is something that is not very usual in Uruguay. So what happened with a very strong lobbying of the holders of the collective rights and representatives of the interpreters, musical interpreters, and the extension of the term for 20 years somehow places us at a level that is more similar to the terms that we have in the region. But the problem is that many works or recordings that were in the public domain will go back to the private domain. And to our understanding, this increases the barriers to approach culture and education. And there is not a good solution for the problems, social problems that we have with artists and all the people that are working in this combination. Somehow, this was stated, or we connected it with an idea of the emergency
una idea como de atender la de
to take care of the situation with the elderly age or in the last years of life of the artist, especially in the cases of interpreters that are in execution, because for the authors it was after death. So the beneficiaries would be the uh, heirs, and we didn't have any previous study or with these organizations that proposed a reform, but it was not based on any study or analysis, prior analysis or study. And this is something that I wanted to ask Carolina and Salvador, the realities of Mexico and Colombia. How much incidence does this kind of study has, or what can we do so that we can use, this to think of studies of impact or evidence of these impacts? This term extension is what we had been discussing since 2013, where there was a proposal that finally was rejected. And there was a contrast to the situation between 2030 to 2019 with regards to the effectiveness of the resistance that could have occurred with this change. This is another topic that allows us to think about the orthodoxy, the current orthodoxy,
nacionalismo que temos
the nationalism that we have in the conception of the copyright, and left us, sort of like a sour taste. Last year, we worked hard, and this year, together with this issue about the coronavirus, we are more deactivated with regards to activism in this topic. But in addition to this process, this parliamentary period that ended with not very good news for public interest with regards to IP, this was a period that has some interesting progress, but they were not finally turned into an effective law of limitations and exceptions of copyright that would have generated a balance or better legislative or regulatory balance to be able to apply these in the new situations that we have seen with the pandemics with regards to the digital access to the studies. The current law in Uruguay in the chapter of limitations and exceptions does not contemplate the possibility of education online, repositories, and libraries also. In the physical spaces, there are no exceptions for libraries. And the few exceptions for educations that exist have to do with things that are obsolete or minimal, like being able to represent or execute some work, in some school space or a radio discussion on content, educational content. But in our law, we do not have anything for education. So these years between 2014 and 2019, the last legislative period, we were working together with other organizations such as the Universidad de la República, the Students Organization, Association of Archive Workers, in combination with the Council of Copyrights, the Culture Ministry, to try to promote a better balance and new exceptions so that they would take into account the reality of education and that somehow would bring us out of some exceptionality that we have in Uruguay. Maybe in Uruguay we have progress and advances in the law agenda, but it is also
atrasado en cierto
sort of
sentido.
delayed or limited in these regards. There was a strong opposition from the Cámara de Libros and in Esagado made it difficult for us to continue moving forward. So this has some limitations for education, and there were votings in one of the chambers, and they provided a lot of social, or they had a lot of social support, and they had the idea that this was something that was going to progress, but then it remained stagnated, not allowing it to move forward in the deputies chamber with a lot of resistance and media deployment in the Cámara del Libro and actors that are aligned in a maximalist way for copyright. Although we attempted several negotiations to include the objections that, or see the objections that could occur or that were stated, but finally we never got to an agreement, and the actors of education in Uruguay is the Universidad de la República, the National Federation of Public Education, with the support of the Council of Copyright. All are institutional players, and they try to implement the law, but by the end of the period, with some suggestions for change, but they couldn't do it. Not as fast as an urgent as the other amendment, which was the extension of the terms. So if we go to the current situation with a law that was never reviewed and adapted properly for this perspective of uh, human rights, it was adapted for the commercial part because in Uruguay in 2013 we started. In 2013,
Para
there was
armonizar
an amendment to harmonize the law with regards to the salt pigs, but there was no, from the point of view of the authors, there is no regulation as what to do with the contracts, and so finally, this legislation has not approached a comprehensive reform with a human rights perspective, and we continue to think that the way to follow is to follow what has been recommended by the special narrator in the human rights of the United Nations. This is sort of like the framework, but we have not been able to be convincing in these regards. And in our country, we have not critically evaluated the demands from entrepreneurial and corporate sectors for the copyright to be more restrictive. And apparently, these are the only players that really have had a capacity to
últimos
exert
años.
effective pressure in the last years. And this now, in the scenario of the pandemics, the schools and the libraries were closed for some time between March and June, if I remember well, and education went on to online platforms. And today, the online education continues to be a support to contain these health emergency, but there is no really access to educational contents and how the platforms and the libraries, how can they facilitate to be able to study from home or to study in a semi face-to-face way. There has been no polemics or scandals in these months, but this doesn't mean that because we're in a pandemic, the conversation cannot occur, because it has happened in Mexico. We're going to listen to Salvador, what he has to say, but we do consider that the current legislation is not a tool with which we could do policies for the access of knowledge in the pandemic times.
Así que
and
bueno,
also access to education when we have a sanitary emergency. So we have this legal situation that this is a reality that is parallel to a more practical reality where there have been significant progress in Uruguay by constructing different projects and repositories, etc. So this is what Patricia is going to talk about a little bit. So you can go on. Thank you very much, Mariana. Before we talk about some progress made, not everything is so dark. With regards to policies, I'd like to recap on the process that Mariana mentioned of sharing screens. I have a very specific slide that I want to share with you, and it has some ideas to discuss this reform process. I must confess that this is the result.
ação dos últimos 5 anos. E bom, na
These are really ideas. It has to do with issues that we have discussed with our colleagues from other lawyers from other Latin American countries that are experiencing the same questioning. And this is like a vicious circle that we have detected. And I try to summarize it here. The first thing is that the issue that the loss of author in many countries of Latin America, we have differences. Are countries that have added several exceptions, like Chile, for example, but the reality, these countries in Latin America, they have some anachronic laws and also illegal practices of naturalized access. When we talked about this topic, I work with education in Uruguay. We reached the conclusion with the teams, with the teachers, that the state, the public education in Uruguay covers 90% of the pension at the elementary and high school and 80% at university level. So you can see the importance of public education in our country. The state takes as a way of natural access illegality. It counts on it. Why? Well, basically because they do not take in the agenda, in spite of the fact that we have several players, as Mariana was saying, that there was some efforts made, but this is not really an agenda that we can push seriously. It's not so essential because the access today, the illegal access, is natural. It has become natural. And it is not a problem. There are other problems, and it is true that there are other problems having to do with public education. But we have the the practices that have been, the illegal practices that have become natural, and the reform, the level of politicization in the debate, they don't listen to technical matters of law or studies of impact, as Mariana was mentioning, and also the arguments against the reforms are not legal. Are Google argument, like number one, those that are pushing the reforms are being financed by YouTube. It's incredible to listen to those arguments in this kind of debates. Other arguments speak with the symbolic factor of the exceptions, not with the needs that they have from the legal point of view or cultural point of view. Is that people will interpret these exceptions as everything is valid. So this is not a legal argument, but more practical. Now, the issue about politicization of the debate in negotiations, which ends up being a game power. Another important factor is the lack of education on this kind of or literacy in this because the authors do not feel that they're sort of like there is a problem. I'm talking about students, academics. There is a lack of copyrights literacy that is very important. And everything forms part of the same wheel that continues running. Now, talking about the pandemics here, something that is of concern is a topic of risk, the legal unsafety. The existence of this issue cannot be complied with, thinking about the educational system or the operation of the libraries. And these risks are transferred to the students and to the teachers, to the academics, to the people in in the libraries or librarians. This is a conception of the increase of risk in these weaker players, because if the state or the public institutions or the parliament does not bring this topic in its agenda, is transferring the risk indirectly to others. So today, in 2020, in the world pandemics, the fact that education goes out from the privacy of the classroom, of the privacy of sharing a presentation. Well, we don't even have an exception to have an image in order to illustrate teaching. We don't. We have the execution of representation of works in the schools, but showing a film is not foreseen, as copyrights. When we bring this to virtual classrooms and put it on writing and leave it in open blogs, because this is spaces that the teachers are using increasingly now because they're forced to do it. And they are also transferring the practices of sharing many designs of materials. They are transferring this to internet. And this increases the level of risk. And we have to be very attentive to that. I have no doubt that we're going to start seeing if this continues, not because of the pandemics, but because there has been a cultural change worldwide with regards to educational practices. And I think this is coming and it's staying.
Y, y è possibile che apareçam casos que
May be used to make visible the problem. Talking about the problem, then, this has to do with the reform or things, what has to do with exceptions without limitations. But I also want to talk about the fact that we have several policies. For example, Uruguay in this case has policies of open access and open education that we understand that have been used, but they're like a patch. This is a single system. Maybe, well, the example that you see here are the two portals of educational resources that are most important in elementary and high school systems in our country. These are open educational portals, and we are working with Gina Rodesio in this investigation on the role of open education in times of pandemics in the framework of a research that is being done with the centers deployed in Colombia with other countries like Korea, Colombia, Uruguay, where we are taking this forward. This is a comparison with respect to the previous year. We can see what happened with these repositories. They exploded. If you see the statistics, the Ceibal repository increased fourfold the use of these educational part. And the issue here is that the teachers have no idea that they're using open educational resources, but they exist. They're there, it's legal to use them, and they are contextualized according to the study plans and to the reality of each country. That's what is important of open education from the local point of view. But this use, as it triggered, it is for sure, it also triggered the use of any other resource that is circulating in internet with educational purposes, inclusive. It's great to talk to lawyers from other countries. I had lots of consultations from the libraries at times of pandemics because there was an urge for requests to make some materials digital, books that are a must in several curriculums. There was a general pressure on
moneda
the civil
corriente,
society because this was
el
like
director del instituto
something that was regular. The director of the institute, they say teachers are asked me to make visible certain content and they know that it is illegal, so why do they call me? They just wanted to confirm that it was illegal what they were being requested by the teachers. So the topic about the existence of policy of it is important, but it forms part of the ecosystem. So what I want to say is that we have to make the ecosystem healthy. We This is made up of policies and balanced laws. So basically, I try to finish here. There are other things that I wanted to tell you about, but we're going to leave it for the conversation at the end. So I'm going to give the floor to what? Mariana? You tell me whom.
Vamos con Carolina.
Let's go on with
Bueno, pues buenas
Carolina.
tardes.
Okay.
Gracias por esta invitación. Muy feliz de
Thank you
estar
very
aquí
much for the
en medio de la
invitation.
celebración del Congreso. Estar en una sesión de invitada es todo un honor. Amit me dijo muchas cosas, Patricia se
Amit
quedó
has
en
told me
medio
many things.
y
Patricia left many things in my mind,
en
so
Colombia
I would like to
tenemos un
share
proceso de
this. In
exclusión
Colombia,
de
we
derechos
do
académicos
have
que
a
arrancó
process
desafortunadamente con los
for
atentados
exclusions in
a
the
ley Lleras del
copyright,
2011,
which is called as
pero
the Law
en la
Lleras of
actualidad
2011, but it was
también hay una
complicated because this was a law
exoneración de responsabilidad
about the
para
exoneration of
operadores de
responsibility
Internet
for
y se tiene que
internet
trasladar a la legislación
intermediaries,
colombiana el proceso de
which
las
you
10
have
leyes
to
de la
transfer to the Colombian legislation,
pero que
the
ahora debemos iniciar
process of these
escuchando a
notifications in internet, that when we see something that you cannot see in your country or that have been removed because they have copyrights.
mucha resistencia
So this law had a lot of
de
resistance
contenido.
and we could hold it out.
Como hemos presentado
So
la PLC
there was
y
an
dentro de ese
imposition of the
proceso que
TLC and there was another chapter
reforma al derecho de autor que
which was
le hago
the
que te
reform
interrumpa.
for the copyright, not expansion of the term, because here we have enough time, but it had many other things included. I can't remember many of the conditions, but these happened in 2012 and we stopped it, but it started again in 2018, but with the same logic that Uruguay is talking about. We could not resist it because it's a critical situation in 2012 is that they were not contemplated exceptions. In 2018, they came with a whole set of exceptions and they applied pressure and they went to the Congress and that law was passed. So, as Patricia said, we have not lost everything, but resistance allowed us to win on certain things. For example, Colombia is legal in a public lending in libraries, which was illegal up to 2018. But this is something general, as Patricia said. There is some tolerance, a culture to infraction or to breaching. So all those million pesos that you allocate in the budget for public
En una actividad
libraries are being used in a private activity, and people were looking at that and they said,
en
well, how are you
2011
doing
y
this?
2012 el
So
ministerio
we were able to win over that, and this was something that
que las
we were
personas en
able to
Colombia
have an exception so that people,
podían
blind people in Colombia,
descargar contenido
could
y descargar
digitalize the content of these devices, and they started to deliver this massively, and so that blind people could have access to this material.
tiene un problema y es que la
It's
excepción
got a
tiene
problem because the
leyes
limited
legales
exceptions are in the light of the
y que
Treaty of
tendría que ser
Marrakech, but it
legalizado algo
means
y eso
that
me
something was
recuerda un
legalized.
poco
And this
lo que
reminds
Patricia
me a
nos
bit
estaba diciendo de
of what
educación.
Patricia was
Mira,
saying
para
about
hacer un pluridiplomado
education.
en Colombia ahora
When
estamos
you
en
would
ciega
think that
que dicen que
In
se hacen las
Colombia,
cosas
blind
en
people
forma ilegal
had to
y
do
dicen, bueno, pero ¿cuál es el
things
problema? Si
illegally,
nadie va
you would ask yourself, what's the
nadie va
problem if
a
no one is
ayudar a un
going
ciego,
to
entonces no lo vamos a
sue
sacar
a
de la
person who's
cárcel.
blind?
Entonces
Yes,
nos
but then
estamos
how
es,
is it that we are
apoyando
basing ourselves on illegal practices. And what's the problem? If you
Legal não pode dar.
practice, you cannot either destine money to it or budget. We want that too. We want some other exceptions. I'm not going to delve deeply into this. And we won on orphan work. To me, it was decisive because the process is so complex. It hasn't been regulatory and it won't serve us for anything. Also, for example, they allowed screens on library, especially for virtual education. We were not able to move these. One thing has to do with what Patricia was saying, but in an exponential manner because Uruguay has, well, everyone in Latin America, the reality in Guatemala is not everyone has iPads or devices. In Colombia, 50% of the people are connected, but connection is not necessarily good. I mean, for quality type of connection and what virtual education requires, no, we have a serious problem in rural areas. That has meant or implied that Colombian public education during the pandemic has become WhatsApp for many people. And because if your home is marked as connected, probably the connection is because of someone who has a cell phone or a mobile. And if everyone is depending on the mobile phone, maybe the kid will be the last one to have access. But I would like to highlight something. Colombia, as opposed to countries like Uruguay, doesn't invest in public educational resources. We buy from the publishing companies, and that generates a market which for the country is very small. I mean, you really don't invest in resources for education in the public sector. But for publishing companies, that's a very important piece of their budget that generates tension. Here in, I mean, in this pandemic, many of the items which depend, I mean, many of the kids have never had uh, this type of resources in their hands. The government had to distribute it throughout the national territory because that's the only thing that can guarantee education in some, I mean, in some degree for children. And that's impressive. I don't know what the contents are like. This is something that we should be studying. But pandemic, I mean, made children have access to an ebook for the first time in Colombia during the pandemic. Precisely thinking about the effects of the pandemic in this type of context, we've started a series called Verbenas to talk about the problems generated by the pandemic. You can consult these. There's a bit of art and some other topics, but I want to call your attention upon one. It's a case, like I told us, it's called a Cine Club. It's a film or movie club, and it's the first one in Bogota. So very important in copyrights when they start working with public work and even with Colombian documentaries where they have the authorization from the directors. Facebook blocks them automatically. Why? Well, property rights. And there's a big fight when you do a streaming, they download it and that's it. So that's where have to start thinking about what cultural
Podemos manejar isso com grande poder, com um algoritmo. E eu deixaria por aí, Mariana. Muito obrigado.
Gracias,
Mariana.
Carolina.
Thank you very much, Carolina. Yes, many interesting issues. I had forgotten to mention that not everyone has lost their place because the Marrakesh Treaty was regulated. And well, before going to Salvador, just wanted to remind you that if you have any questions or comments, there's a Q&A session, and you can click on the button at the lower part, on the lower part of the screen, to ask questions and have answers. I don't know if you have access to the chat as participants, but surely at least to access for the questions you can do so. So we will be answering your questions. There's also a chat in Telegram. I hope you can find it in the page of this session within the Global Congress web. And I am going to write it also here in this chat. Well, there's a space in Telegram for you to continue chatting once the session is finished. So I give the floor to Salvador now. Good morning. Well, Mexico's situation is not different from the situations you have been describing. In many cases, it would be sufficient to just, I mean, it would be just about a matter of changing the name of the country, but the situation is the same. Well, the problem in copyright in Mexico started in the 90s. It's really, well, the law is anachronic, as Patricia was describing in her summary. And it's a law which simply has been, I mean, they've tried to update it and it has had partial reforms, but there has never been any, major reform that can touch upon the digital and the technology aspect. The most recent one was on licensing, and it tried to integrate digital concepts, but always under the commercial perspective and authors. Not even authors, it's more the industry, because we've also received complaints from the authors that they don't feel represented by the reform or by the associations or the publishing companies. So it's this cooperativism which has fostered reforms to the copyright law during the history in Mexico. As Carolina was saying, it's the ecosystem. The ecosystem is totally imbalanced vis-a-vis the presence of the excessive exercise of cooperativism within copyrights. So things as exceptions or public domain really represent a minimum fraction. It is totally up, outdated, except for the copyrights in Mexico. They're contained only in two articles, and these are very generic expressions, very abstract. It's true that, I mean, the right should be abstract, but we believe that the definitions in Mexico, to me, are so open that they don't give much room to understand that you are under a specific objection or exception, and that therefore you can have access to education openly. There is an expression that says that you can freely use object or protected work under copyright, and as long as you do it for non-profit purposes. So to what extent is it profit or non-profit or simply an agreement of recovery? Someone was telling me once that it was like in a movie club where they would go from approved movies, but they would sell inside candies and caramels. So is there profit or isn't there? I mean, profit. It's my general understanding of commercial law. I would say there's no profit because you're not earning any profit from what you're doing. So we're, struggling with it day to day, trying to reinvent or reimagine, or trying to take those general and abstract expressions to try to make them more specific. And from, I mean, since the 90s, the exceptions have not been reformed. So the most recent work was precisely the inclusion of the concept of the Marrakesh Treaty for blind people, and within those exceptions, it's very generic and it's very short also, but at least we have
Pelo menos
specificity. And we have that expressed from the legislation in Mexico where they say they wanted their intention was to take the spirit of the Marrakesh Treaty. So within this generic expression and following the reform, we can say that Mexico is within these reforms or is part of this reform. As I said before, all the reforms have tended or aimed at the copyrights and the association point of view. Those kind of unions, or at least they work as unions, and their point of view is very delayed. The digital part was integrated through this last reform at the end of July this year. And just like what Mariana was saying, I felt identified with the changes she mentioned as far as the law in Uruguay. Well, here these reforms that were introduced, they were introducing changes in, for example, the Treaty of the United States and the Canada Treaty. This trilateral treaty we have with Mexico also integrates a lot of what was known before as NAFTA or Telecal, but renovated a bit and focused on avoiding what we know as piracy. In Mexico, there is also a very strong culture to criminalize or penalize copyrights, and many times they call it piracy. So a lot of work has been carried out, and you can hear this from experiences of other countries regarding integrating into the Mexican minds that to not think of this as evil all the time. So when really exceptions kind of disappear, and under this piracy concept and this name or title, people keep this in mind. And although we do it day to day, I felt identified with the normalization. When you mentioned normalization of illegal conduct or behavior, many people have recognized that what they call piracy is really an important action for students who need the book. But the way it is drafted, it's only, I mean, it's penalized. There's no specific exception that talks about, for example, photocopies to study for students. Maybe we interpret very openly the exception which talks about non-profit use and personal use. Private personal use, in that case, we can talk about photocopies, but it's very common for photocopies to be, made on a large scale and massively. It's really for the entire classroom. So we're forcing that interpretation a bit. As I said before, this Telmec integration generated many changes. Two of the main ones are integration of the notice and takedown in Mexico, as I said before, in July this year. They're totally integrated. We interpret it as a form of integrated censor. Even if we said, I mean, we insisted upon in social media that these type of figures can be used to censor speeches or discourses that are not appealing to the politicians, in the motivation to not want to do not want people to disseminate this. And this interpretation is not only ours, there are also interpretations of the High Commission of the United States, in that the United Nations, in that sense, United States and Canada. We try to replicate all these arguments and present them in Mexico. They didn't listen to us much. We went to the Senate. It lasted a few hours. We listened carefully, but we in the end realized that our arguments were not incorporated into the reform. There was an express reform which lasted 2 days, one day in the chamber. At on the third day, it was signed and approved at an official level in Mexico. The second change that was integrated or incorporated with this reforms was the penalization of digital locks. These technological measures are integrated into digital products in order to prevent, I mean, avoid copies. At the beginning, it was very draconian. Any change was punished, but based after our pressure and after our work with the legislation, some exceptions were incorporated, very mild exceptions, but in general, these type of allusions continue to be punished and criminalized. In it was only not only the copyrights, but the federal law. It's not only violations, but also the penalties that deprive you from freedom. There's a big ignorance in the legislation in Mexico regarding digital matters. We were listening to the reflections of some of the deputies where they couldn't understand. They were talking about the fact that these logs did not intervene in the reparation of Harvard or the physical part of the devices, and they would never understand that interaction between the software, the algorithm, and many times with the hardware. I mean, sometimes you open it and you detect that it has been repaired, or in order to repair it, you additionally need to open some kind of digital log or software that will allow you to make this modification or repair this interaction between physical and digital. They were never able to understand it. They could never understand that there was certain criminalization to a certain extent, and they would say, no, you can open it, you can repair it, you can open your cell phone, no problem. That has nothing to do with, with what we're talking about. So really they never understood that interaction, how the concept of the technological device and the software is one single concept. We tried to explain it many times. We even gave it a political uh, tone to what we're saying that we wanted to, change the reforms because we wanted to integrate things into, the modern age. But all of these arguments were not used. And the arguments of the counterparty, the legal part of these are very old. These are classical copyrights, traditional ones. They would always say, no, you don't want authors to be paid. Eh, It's not part of the culture. I mean, it's so obsolete. I see a lot of this division in Mexico between the advocates, the old advocates of, trade, copyrights, etc., and the other people who talk from the point of view of human rights and a general ecosystem which seeks to have education. And public domain in Mexico is weak. I'm sorry, Salvador, the session is about to close in 2 minutes. So, oh, sorry. So I'll stop now and we can have room for questions. I don't know if it'll give us time for the discussion, but we can continue it in Telegram. So please recap on your idea. Well, that was in general the law about uh, aimed at the mercantile and very weak insofar as public domain. And it's not promising for the future unless we make a comprehensive reform in the legislation. How many coincidences, Salvador? Many coincidences. Yes, many points. If common, I would just, move my head. Yes. Well, there's not a lot of time left because the session is about to conclude in 1 minute, a few seconds. This is very strict as far as time. So I invite you to continue in the Telegram chat. If you go to the web page of Global Congress and you go to the page of this session, you will find the link to Telegram. We can continue chatting there. There was a very interesting question by Teresa in Portugal regarding the use of materials with free license or without license, or materials with copyrights in education, and they're trying to understand how this works in Europe and investigating and researching. So I am going to raise this question in Telegram to see if Teresa can visit us there. Okay, so we thank you very much for your participation, and it's time now to say goodbye. Thank you very much. Bye bye.